Hi friends, in this video we are going to deal with the important judgment titled The State of Madhya Pradesh and Others versus SOMDUTT SHARMA, pronounced on 29th September 2021. This judgment deals with that the Irrigation Department of State of Madhya Pradesh is not an industrial establishment under Section 25L of the Industrial Disputes Act. To know more about this case synopsis, please watch the video fully. The facts of the case would be that SOMDUTT SHARMA was appointed as a daily wage employee on the post of helper in the Irrigation Department of State of Madhya Pradesh. On December 1, 1995, his employment was terminated. On Chief Minister's directions, Sharma was again taken back in service on August 11, 2004, but his employment was terminated again on July 2, 2005. Sharma raised a dispute which was referred by the appropriate government to the decision of the Labour Court. The tribunal ordered for Sharma's reinstatement since the state did not comply with Section 25N of the ID Act. The tribunal, however, declined to grant back wages. Agreed by the tribunal's award, the state approached the single judge. The single judge affirmed the award. The division bench also affirmed the decision by the single judge of upholding the tribunal's award. The learned Deputy Advocate General of the state submitted that Irrigation Department of the state is not an industrial establishment within the meaning of Section 25L of the ID Act. The learned counsel for Sharma, however, alleged that the Irrigation Department of the state, being an industrial establishment, was under obligation to comply with Section 25N of the ID Act of obtaining permission from the appropriate government, and also argued that the Irrigation Department of State is an industrial establishment as it is a factory as defined in Class M of Section 2 of the Factories Act. The issue before the Supreme Court is whether the Irrigation Department is an industrial establishment as defined in Section 25L of the ID Act. The Supreme Court has held that an establishment cannot be termed as a factory unless it is carrying on manufacturing process. The manufacturing process is defined under Class K of Section 2 of the Factories Act. The Supreme Court has carefully perused the findings recorded by Labour Court as well as the High Court and found that the crucial question whether the Irrigation Department of the state is a factory within the meaning of Class K of Section 2 of the Factories Act is not considered at all. Even the single judge has not adverted to this aspect. The division bench has stated that as the Irrigation Department is pumping water and sewage, it will be governed by subclass 2 of Class K of Section 2 of the Factories Act. Sharma has only relied upon subclass 2 of Class K of Section 2 of the Factories Act. The Irrigation Department looks after creation and maintenance of irrigation potential through construction of water resources projects. The Irrigation Department also deals with disaster management, calamity management, maintenance of flood control works, reservoir operations, etc. None of these functions will attract the definition of industrial establishment. Even assuming that some of the employees may be doing the work of pumping of water, that is not sufficient to hold that Irrigation Department of the state is carrying on manufacturing process. Even if the activity of operation of pumps is carried on by few employees, the Irrigation Department does not carry on manufacturing process. As it is not carrying on manufacturing process, it is not a factory within the meaning of Class M of Section 2 of the Factories Act. Therefore, the Irrigation Department of the state will not be an industrial establishment within the meaning of Section 25L of ID Act. The Labour Court as well as single judge and the division bench have not adverted to the question whether Irrigation Department of the state is an industrial establishment within the meaning of Section 25L of ID Act. There is no finding recorded that the Irrigation Department of the state is doing manufacturing activity as provided in subclass K of Section 2 of the Factories Act. The Supreme Court has set aside the impugned orders and held that the termination of Sharma was legal and valid. Friends, to conclude, in this video we have seen that the Irrigation Department of the State of Madhya Pradesh is not an industrial establishment under Section 25L of the Industrial Disputes Act as per the State of Madhya Pradesh and others versus SOMDUTT SHARMA case. In the next video, I will see you with yet another case synopsis. Until then, I take leave of you. Bye.